Thank the chairman. Professor Turley, I'd like to start where you started because you said something that I think bears repeating. You said, I'm not a supporter of President Trump. I voted against him in 2016, and I have previously voted for Presidents Clinton and Obama. But despite your political preferences and persuasions, you reached this conclusion. The current legal case for impeachment is not just woefully inadequate, but in some respects dangerous as the basis for impeachment of an American president. So let me start by commending you for being the kind of example of what hopefully everyone on this committee will do as we approach the task that we have of determining whether or not there were any impeachable offenses here. One of the problems that you've articulated as leading you to the conclusion of calling this the, should it proceed, the shortest impeachment proceeding with the thinnest evidentiary record and the narrowest grounds ever attempted to impeach a president, is the fact that there has been this ever-changing, constantly evolving, moving target of accusations, if you will. The July 25th phone call started out as an alleged quid pro quo and briefly became an extortion scheme, a bribery scheme. I think it's back to quid pro quo. Now, besides pointing out that both Speaker Pelosi and Chairman Schiff waited until almost every witness had been deposed before they even started to use the term bribery, I think you've clearly articulated why you think the definitions that they have used publicly are flawed, if not unconstitutional, both in the 18th century or in the 21st century. But would you agree with me that bribery under any valid definition requires that a specific quid pro quo be proven?
Yes, more importantly, the Supreme Court has focused on that issue, as well as what is the definition of a quid pro quo.
So if military aid or security assistance is part of that quid pro quo, where in the July 25th transcript does President Trump ever suggest that he intends to withhold military aid for any reason?
He doesn't. And that's the reason we keep on hearing the words circumstantial and inferential. And that's what is so concerning, is that those would be appropriate terms. It's not that you can't have a circumstantial case. Those would be appropriate terms if these were unknowable facts. But the problem is that you have so many witnesses that have not been subpoenaed, so many witnesses that we've not heard from.
Right. You know. So if it's not in the transcript, then it's got to come from witness testimony, and I assume you've reviewed all the witness testimony. So you know that no witness has testified that they either heard President Trump or were told by President Trump to withhold military aid for any reason, correct?
Correct.
So let me turn to the issue of obstruction of justice quickly. I think you assumed, as I did, that when Democrats have been talking about obstruction, it was specifically related to the Ukraine issue. And I know you've talked about that a lot today. You've clearly stated that you think that President Trump had no corrupt intent on page 39 of your report. You said something else, I think, that bears repeating today. You were highlighting the fact that the Democrats appear to be taking the position that if a president seeks judicial review over executive branch testimony or documents subpoenaed by Congress, that rather than letting the courts be the arbiter, Congress can simply impeach the president for obstruction based on that. Did I hear you say that if we were to proceed on that basis, that that would be an abuse of power?
I did, and let me be very clear about this. I don't disagree with my colleagues that nothing in the Constitution says you have to go to a court or wait for a court. That's not what I'm saying. What I'm saying is that if you want a well-based, a legitimate impeachment case, to set this abbreviated schedule, demand documents, and then impeach because they haven't been turned over when they go to a court, when the president goes to a court, I think that is an abuse of power. That's not what happened in Nixon. And in fact, the ultimate decision in Nixon was that there are legitimate executive privilege claims that could be raised. And some of them deal with the type of aides involved in this case, like a national security advisor, like a White House counsel. And so the concern here is not that that you can't ever impeach a president unless you go to court. It's just that you shouldn't when you have time to do it.
So if I were to summarize your testimony, no bribery, no extortion, no obstruction of justice, no abuse of power. Is that fair?
Not on this record.